Good evening. Good evening. Good evening. Good evening. And welcome to Defense Diaries. I am your host, Bob Mata. And I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, is that the official? Is this getting turned into a live? Into a podcast?
Honey, just say your tagline.
Wow. Hey, babe. Hey, all.
Hey. So this is our continuing coverage. Even today, our continuing coverage from earlier today when Allie was going through with you guys the motion hearing that went on this morning, which I have no idea what it was because I was doing something else. Was it interesting?
It was like Brennan's like blah, 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 blah. The most interesting thing was when Judge Cannone cut off Alessi just to say, I'm going to deny this Commonwealth's motion. So I don't know why she doesn't do that more often, why she doesn't say where she's leaning, why she doesn't. I've read all of your arguments and this is my position. I'll let you guys each speak knowing that's where I'm leaning right now.
Well, how magnanimous of her.
Motions and lemonade.
I'm gonna give you a little something before I lay down the pipe. Drop this little document. So, as most of you probably already know, she has filed her response, her order on the defense's motion to dismiss. And surprise, surprise, we're not going to keep you waiting with bated breath. She denied it, of course. So it does require us to go through it, though, because it's an interesting read, to say the least.
It does. And the other document that we received between the first live and this live was the defense's response to the Commonwealth's motion to keep out Officer Easter as or former law enforcement, FBI, whatever he is, Easter, as their Bowdoin expert. And it was chock full of, tons of examples in other jurisdictions of exactly this witness doing exactly this thing. There's a lot of people out there being like, a witness can't, that doesn't happen.
I'll be right back. The dog's trapped in the bathroom.
Witnesses don't just get on the stand and talk about how the police officers should have investigated someone else or they didn't do their investigation right. Yeah, it does. It happens all the time. So I don't know if we're gonna go through that at all, or if we're just gonna do the motion to dismiss.
We're sorry. All circuits are busy. Please try again later.
I don't know, Mandy. I think it's getting old. But, yeah, I guess many of you have already heard some tidbits and updates about the judge's ruling, but I don't know. It's going to give some time for people to come in, but they may be, all doing getting their intel elsewhere or busy, this might be it for now.
I imagine it'll grow. It's usually takes 10 minutes for people to get plus we just created it. So it was a surprise live. Pop-up live. Pop-up.
Grin for
live.
me. Thank you for your generosity. Love you both. I have to catch up on the live from earlier, so I'm going to do that. Feed Bob, Scout for President.
Scout for president, indeed. She just bilked me out of $40 to go shopping. I'm like, you've got a ton of money on your green light. She's like, yeah, but I don't like to spend that. I'm like, so what? You just like to mooch off of me? She's like, yeah, you're my daddy. Like, wow. I'm like, okay. Hey.
See what Mandy's comment is there?
Bob got you all for one. I love it. I love it.
No, got you one for Allie.
Oh, no doubt. No, Trevor, we've got 4 kids, man. Definitely not a new dad. I'm an old dad. I'm old. We've got old kids. We've got grown kids. One's getting married in June. Now there's a firefighter who gave us our first grandchild. And then we got the second wave. Wave 2. Oh, it's a joke. Never mind. Sorry. Oh,
that was for the chat, apparently. That's to calm the chat down. Like, okay, whistle.
Oh, that's like a whistle. It's like a referee.
Yeah.
All right. Mandy's putting some new toys in there. I like it. 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 Oh, she's gotten better at the hi-hat too. I like it. All right. So you want to start going through this thing? How do you want to do it? Do you want to do it alternating pages?
No, just got it. Alternating pages seems. Let me look at it again. See if I think there's sections.
I mean, there's sections.
Right. So that's kind of
okay.
My thought on the whole process.
Is that your thought on the whole process?
Yeah.
Is that what your thinking is on the entire process? All right.
Yeah. There's an introduction.
Okay. All right. I call the intro.
The intro's good because the intro's like,
oh, wait, no. Are we looking at the same thing? I'm looking at the redacted 39 page.
I'm looking at 37 pages. So
say what? All right, wait. Tracy sent a couple of things. Let me check the other thing out.
Oh yeah, you're right. The introduction ends on page 3.
I don't even see an intro. Mine goes right into, doesn't say intro. It has the first page where it says, oh, discussion. All right.
Sorry. I just assumed, flipping quickly, that it was introduction.
Okay. All right. All right. So once again, I call the cover page. And then you can do the discussion. And then I'll do, the next thing's probably bigger. Well, there is a subsection.
Chris given $5 is legit only for the Seinfeld reference.
I live in Seinfeld references. It's like I could speak entirely in Seinfeld and Big Lebowski references. I could have my entire lexicon would be Seinfeldisms, Curb Your Enthusiasm as well, and Big Lebowski.
I don't think there are any Curb Your Enthusiasm like things like there are in Seinfeld.
What?
Like, I don't think what. Yeah.
Do you not? What?
Yes,
what?
Yeah.
What?
Okay.
Do you respect Wood, Allison? Do you respect Wood?
Yes.
There are a million.
Revenge Store.
No. What? Spite Store. Come on.
Spite Store.
All right, let me pull this guy up. We've killed enough time here. All right, so I'm gonna do pretty. I mean, that's
all right. Take it back.
Right, that was crazy that you said that. You sounded like Shands. She loves Seinfeld, hates Curbed.
Hey, Jay.
What's up, J-Bo? Do you have a good live today, brother? With Adelson? I was going to try to catch it on the drive home from ISU, but I got sucked into some pizza party. Derble. Okay, let me pull it up. All right, do you want me to do a formal intro?
Yeah, sure.
Yeah? Okay.
Yeah.
All right. Okay.
But say with our continuing coverage before you introduce me.
Yes, ma'am. Yes, ma'am. I shall. Okay, you guys ready? 3, 2, 1. Welcome to the docket presented by Defense Diaries. I am your host, Bob Mata, and this is our continuing coverage of the Commonwealth of Massachusetts versus Karen Reed. And I am once again joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So we got the long-awaited opinion / order from Judge Cannone on the motion to dismiss. Yes.
Yes.
So let's dig in. You want to just dig into this thing?
Yeah. Why don't you start us off?
I shall. Okay, so it's a memorandum of decision and order on defendant's motion to dismiss for extraordinary governmental misconduct. So on June 9th of 2022, a Norfolk County grand jury indicted defendant Karen Reed on charges of second-degree unaliving, red rumming, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death following the death of her boyfriend, John O'Keefe, on January 29th of 2022. The Commonwealth's theory of the case is that the defendant, while intoxicated, struck and killed O'Keefe while operating her vehicle in reverse and then left the scene. Trial on the matter began in April of 2024 and concluded on July 1 of 2024 with a mistrial. The matter is set for retrial April 1 of 2025. Ahead of the retrial, the defendant has filed a motion to dismiss for extraordinary governmental misconduct. Such a drastic sanction is justified only in response to the most egregious and truly harmful conduct. In all but the worst cases, the appropriate remedy is at best a new trial, such as the one that is scheduled to begin soon here. How lucky. Because the claim violations here, do not rise to a level that would justify the most draconian sanction of dismissal. And because the defendant's constitutional rights can be fully protected in the coming trial, her motion to dismiss is denied.
And before you move on to the discussion section, and I'm sure this is a very unpopular opinion, but when we were discussing this initially, I was of the mindset that most of the prejudice could be cured in the second trial. A lot of it, but I still think the inverted video and the attempt to pull the wool over the eyes of the court and the jury, I think that is the worst possible case. But we'll get into it.
Well, when we get to that, both of us, when we read it, like I quietly in my brain was like, oh my God, like she literally just cited the case that she should be citing in granting it and dismissing the case, but she uses it in the opposite. So, but we'll get there. All right, you ready? You're up.
No, you're doing discussion and then I'll.
Oh, mommy. All right.
People are. Ay.
Okay. Discussion. Dismissal of criminal charges with prejudice is the most severe sanction that the court can impose in a criminal case to remedy misconduct on the part of the Commonwealth. And so here's the deal. I'm not going to cite all the cases because this is case heavy. I'm going to read it. What do you think? What do you
just indicate is the Massachusetts case from this year? That's what I do.
For every single one of them?
Well, citing Massachusetts case law. I don't know, babe. Play it by ear because sometimes they're going to reference back to the case again. So
you mean with id? Id.
No, you don't have to say id. You can
id. I like saying id though.
Okay.
So I'm going to say id because I enjoy it.
This is not very formal for podcast.
Is it not? Should we restart again?
All circuits are busy. Please try again later.
Wow.
And I have no idea how Darren's getting those little sounds out.
He must love those little sound effects. He hasn't texted me complaining about him though yet.
Yeah, but we haven't re-listened to them in podcast form to make sure they're not still just there.
Wow, she is just okay. All right, let's get serious. No more messing around. Somebody left a comment like, "Hey, quit messing around. Just get right to it. You take too long. Good luck." It was the weirdest.
Can
So
just fast forward. He can just
bizarre comment.
start the live 10 minutes late.
Yeah. Well, I mean, that's the thing. Okay. So I'm going to restart the discussion. So, Darren, forget all that. And I'm going to go right into the discussion right now. It was a real formal reading. So, discussion dismissal of criminal charges with prejudice is the most severe sanction that the court can impose in a criminal case to remedy conduct on the part of the Commonwealth. And that comes from Commonwealth v. Mason, a 2009 case. The dismissal of a criminal case is a remedy of last resort because it precludes a public trial and terminates criminal proceedings. And that's Commonwealth v. Kronk, which I believe the defense cited, 1985. Absent egregious misconduct, or at least a serious threat of prejudice, the remedy of dismissal infringes too severely on the public interest in bringing guilty persons to justice. Commonwealth v. Sinelli, and that is a 1983 case. So they continue. The judge continues with citing cases. A dismissal with prejudice for government misconduct is very strong medicine, and it should be prescribed only when the government's misconduct is so intentional and so egregious that a new trial is not an adequate remedy.
I mean, there's a lot of facts here that indicate that is just the case here. The government misconduct is so intentional and is so egregious. It's whether or not she thinks it's warrants punishment. And I'll bring this up again when we get to the portion of the citation that you referenced a moment ago, where we were both sort of outraged.
I guess my comment would be, if not this, then what? Like, how egregious does it have to be? Them putting an inverted Sally Port video in to fool the jurors into thinking that they're looking at the passenger side of the vehicle in order to hide the fact that Proctor is lurking behind the vehicle. That's not egregious enough. Like, how egregious does it have to be?
To punish them, to deter them from doing it again, which is the point.
Yes. But that's not my question. If not this, then what? What does it need to be? I wish you would have given us an example.
Right.
That would have been awesome.
Well, we haven't read all the sites. Maybe she does.
Okay. You think?
We'll see.
We shall see. So, two parallel legal principles govern the resolution of cases involving prosecutorial misconduct where dismissal is contemplated. Again, Kronk. First, where the prosecutor fails to disclose evidence the defendant is entitled to receive and the defendant is prejudiced by the failure to disclose. A motion to dismiss should not be allowed absent a showing of irremediable harm to the defendant's opportunity to obtain a fair trial.
Now,
and that's still Kronk.
Yeah, and before you read the rest of the portion that she cited there, I would agree on certain late disclosures, some of the discovery issues. Those kind of things can be remedied because she's getting a new trial. So now she has the opportunity to have all that stuff and address it timely. But that is a minimalization of the issues before this court.
Such a drastic remedy. Well, I'm going to use an Allison. Moving on. Such a drastic remedy would be appropriate where failure to comply with discovery procedures results in an irremediable harm to a defendant that prevents the possibility of a fair trial. Alternatively, in rare circumstances, prosecutorial misconduct that is egregious, deliberate, and intentional, or that results in a violation of constitutional rights may give rise to presumptive prejudice. And the drastic remedy of dismissal of charges may become an appropriate remedy. And that, once again, is Kronk.
Deliberate, egregious, intentional. The inverted video is all of those things.
If not this, then what? The latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. Now, I'm going to read that again.
Right. Just that second part, please.
I'm going to read the whole thing again.
All right.
Just
Do it.
the latter theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct.
And when you're dealing with a situation where you've got law enforcement or a law enforcement agency who has had repeated issues with integrity, honesty, all the way up to criminal activity that they're all involved in, and then they pull something like this, how is there not a stronger deterrent warranted here? How could she write those words and not think, this might be conduct that I really do believe should be deterred? Like, I would expect, Bob you mentioned this on a live that some of our listeners may not have ever heard, but that when the judge comes out, as she did with the defense in this case, and reads them the riot act to put the fear of God into them, then not to take the most, not to put in place the strongest remedy. I would have liked to see some language like that here. So let's see if she puts the fear of God into them, at least, if she reprimands them in this response, if she speaks to how closely she found this situation to warrant such a remedy, to almost warrant the strongest in the books because it was so bad and warrants a deterrent.
And I'm going to say it one more time. If not here, then where? If not now, then when? Any of those phrases, this is the perfect time to lay the hammer down on the Canton Police Department, on the Massachusetts State Police. This is it. This is the perfect time to do it. This is exactly when you're talking about a motion to suppress, and I'm always talking about it has to have teeth, and the teeth is the suppression of the evidence that many times is the piece of evidence that the state really, really needs in order to move forward on that particular charge. Therefore, they typically have to drop that charge. That is a drastic remedy for a cop violating somebody's constitutional rights.
And they don't do it just because, it's out of fairness to the defendant, this or that. Nope. It is because, as it says right here, a stronger deterrent is warranted to prevent repetition of such misconduct.
That's why you need teeth.
Suppress evidence.
Why you need teeth. That's exactly why you need teeth. That's why they do it, to stop them from continually violating our rights. So the defendant here argues that the Commonwealth committed egregious discovery violations by destroying and or withholding exculpatory evidence, and that a Massachusetts state trooper interfered with the jury during the first trial, warranting dismissal of the charges. As discussed below.
Sorry.
Yes.
I just felt like she just minimalized everything in that 2-sentence. This is not just about destroying and withholding exculpatory evidence. It's about lying to the jury. It's about putting on perjured testimony. Either knowingly,
Buttercup. This whole thing is she's an apologist for the state, for the Commonwealth, for the cops. It's ridiculous.
Well, let's see. There's 27 pages. Maybe she's going to get in there and really, like I said.
Never does. It's one, she actually says more than Mr. Ipsy Dixit himself. Like, she adds things that I didn't even hear Hank Brennan say in terms of excuses as to why it's not that bad. But we'll get there. So.
Oh, jeez.
Now I forget where I was.
Let's start with as discussed below.
As discussed below, the defendant has not demonstrated that she suffered any prejudice as a result of the discovery violations that cannot be cured by her new trial, and has not substantiated her claims regarding interference with the jury, which, as discussed in detail below, are baseless.
Now, the key part of that sentence here is not that she hasn't demonstrated she suffered any prejudice. It's the judge saying she hasn't suffered any prejudice that cannot be cured by her new trial. Now, we're going to obviously circle back to that more and see if we believe that that follows on each of the issues that she goes through one by one. But that is the crux. She's not saying that the defendant hasn't demonstrated that she suffered any prejudice at all. She's saying that cannot be cured by her new trial. So moving on. Paragraph, section 1, Commonwealth's discovery violations. Commonwealth's discovery violations. Discovery obligations. The Due Process Clause of the Federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control, citing a Massachusetts case, as well as Brady v. Maryland, which is the United States Supreme Court case, the watershed case on this topic. And she cites Brady for the proposition that a prosecutor may not withhold evidence that, quote, would tend to exculpate a defendant or reduce the penalty. And I'll mention there that she's also using a very limited definition of exculpatory evidence, and I'll move on. Evidence is exculpatory if it, quote, provides some significant aid to the defendant's case, whether it furnishes corroboration of the defendant's story, calls into question a material, although not indispensable, element of the prosecution's version of the events, or challenges the credibility of a key prosecution witness. All of those things are at issue here with just the inverted video and who was moving around where and when. And they cited a Massachusetts case for that, a 2022 case. Exculpatory material is subject to automatic disclosure. Again, a Massachusetts 2024 case. The Commonwealth's duty to disclose exculpatory evidence to criminal defendants is further reflected in the Massachusetts Rules of Criminal Procedure and Rules of Professional Conduct. She cites to Massachusetts Criminal Rule 14, governing discovery procedures, and Massachusetts Rule of Professional Responsibility, C 3.8D, mandating that prosecutors, quote, make timely disclosure, close quote, of all evidence that, quote, tends to negate the guilt of the accused. This duty is to disclose derives from the core responsibility of a prosecutor to administer justice fairly. Quote, inside a quote, to administer justice fairly. Rule 14 of the Massachusetts Rules of Criminal Procedure pertains to the prosecutor's discovery obligations and the materials subject to automatic disclosure. The rule in effect at the time of discovery issues here provides that the prosecution shall automatically disclose to the defense certain evidence relevant to the case and in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case. This includes, quote, any facts of an exculpatory nature and material and relevant police reports, photographs, tangible objects, all intended exhibits, reports of physical examinations of any person or of scientific tests or experiments, and statements of persons the party intends to call as witnesses, citing Rule 14. Rule 14 further provides that when a party has provided all the discovery required by Rule 14 or a court order, it shall file with the court a certificate of compliance stating to, quote, the best of its knowledge and after reasonable inquiry, the party has disclosed and made available all items subject to discovery. Again, that's Massachusetts rule. And the judge puts a footnote. The Standing Advisory Committee on the Rule of Criminal Procedure recently proposed revisions to Rule 14 in response to the Supreme Judicial Court's request and that's the CPCS case that she cited earlier, for clarification on the definition of exculpatory evidence and the development of a checklist of exculpatory evidence to provide guidance to practitioners. In drafting the proposed revised rules, the committee sought to eliminate the withholding of evidence based on a prosecutor's, quote, estimated or perceived effect on the litigation. Now, that's important here because a lot of times we're screaming that the prosecution, Brennan in this case, that's your estimate of what the evidence shows. That's what you think is exculpatory or helps the defendant or doesn't help the defendant. That is not based on what the facts, the way the defense perceives them, is exculpatory, is helpful, is useful to the defense, impeaches one of your witnesses or doesn't impeach a witness. So this amendment is helpful to the defense bar. And she quotes there the reporter's note to Massachusetts Rule 14, March 1st of 2025. The Supreme Judicial Court adopted the proposed revisions. Thus, the new rule uses the simpler description of material favorable to the defense in lieu of, quote, facts of an exculpatory nature. Now, that right there is what I was saying earlier when I said that the judge was using a very limited view of Brady, and of exculpatory, because it is widely under the U.S. Supreme Court that applies to all of the states as far as your rights as a defendant. It's evidence favorable to the defense. Doesn't have to be indicative of innocence or helpful to their, to show that they are entitled to a lesser sentence. It just has to be favorable to the defense. Okay, moving on. So she cites again to Rule 14. And they indicate that it creates a functional definition of 8 specific ways in which items or information can be, quote, favorable to the defense, and provides a non-exhaustive list of examples of items and information favorable to the defense. In addition to, quote, items and information favorable to the defense being subject of automatic discovery,
Where the hell are you? What page are you on? Are you reading from the right thing?
Footnote still. This is the judge's footnote about how they changed the rule to clarify what exculpatory means and what is subject to automatic disclosure.
Huh. Oh, I
For
see.
you, I mean,
I
I don't know
see.
how Darren's
I see.
that.
It's on page 5. I was
Yeah,
like, where is she? Going
Okay.
up and down. Sorry.
Oh, because you're looking at the Okay.
Yes.
I'm following on my own over here.
I see this.
All right. So I'm gonna start this sentence over. The Supreme Judicial Court adopted the proposed revisions. Thus, the new rule uses a simpler description of materials, quote, favorable to the defense in lieu of, quote, facts of an exculpatory nature. Creates a functional definition of 8 specific ways in which items or information can be, quote, favorable to the defense, and provides a non-exhaustive list of examples of items and information favorable to the defense. Again, citing Rule 14. In addition to items and information favorable to defense being subject to automatic disclosure, investigative materials, items and information other than exculpatory material that are, quote, relevant to the case and in the possession, custody, or control of the prosecutor, the prosecuting office, or any members of the prosecution team are subject to mandatory automatic disclosure under the revised rule. Now, again, I will note here, I think has been long required under the federal constitution and the U.S. Supreme Court jurisprudence that speaks on the expansion of Brady and how exculpatory evidence is evidence that is favorable to the defense. So that was the judge's footnote. Now, returning to the body, she is on paragraph or subsection B. and it's all you, babe.
Canton Police Department surveillance footage. Factual background. There's a footnote too. Following facts are taken from the parties' oral and written submissions, accompanying exhibits, and the court docket. Unless otherwise indicated, the facts stated are not in dispute. Any description of surveillance footage is based on the court's review of the footage, not the parties' descriptions. So on January 29th of 2022, after O'Keefe was found dead in the snow outside of the Albert residence in Canton, Mass., police towed the defendant's vehicle to the Canton Police Department, CPD. There were multiple surveillance cameras in use at the CPD that captured the defendant's vehicle on a flatbed tow truck as it entered the Sally Port at approximately 5:30 p.m. There were also cameras inside the garage, where the vehicle thereafter remained. According to the Commonwealth, surveillance footage from these cameras is automatically overwritten on a regular basis. Footage from the night in question was not lost, however, miraculously. What a miraculous thing. Because CPD Sergeant Di Giampietro, it's a nice Italian guy, huh? Di Giampietro followed his customary practice of downloading the recording to a hard drive in 6-hour segments.
I would note, they also said there was backup drives. They said there were backup files on that, the device itself.
Yeah.
They did.
I know. Where's the metadata?
From the even from the backup.
Where's the metadata? Where's the metadata? Where's the chain of custody? That is what the metadata is in terms of videos. So on February 2nd, 2022, the defendant was charged with manslaughter, motor vehicle homicide, and leaving the scene of personal injury and death in Stoughton District Court. That day, the defendant filed an emergency motion for preservation of evidence pertaining to certain specific evidence in connection with the charges, which was granted. Quote, hereinafter referred to as the preservation order. The preservation order sought to preserve inter alia, quote, all evidence, all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. See Defendant's Exhibit A, the paragraph 6. The lead investigator in this matter, and I've got something to say about that when we get to her defense argument portion here. So the lead investigator in the matter, Massachusetts State Police Trooper Michael, former Massachusetts State Police Trooper Michael Proctor, took possession of requested CPD video of the Sally Port in February of 2022, but did not turn it over to prosecutors. Instead, for reasons unclear on the record, he kept the material in his case file.
I wish she would have written for reasons unexplainable on the record, on this record. For reasons
unknown.
No, but unexplainable, like unjustifiable on this record.
Yeah.
That raise concerns by this court. Something.
Anything to give them a backhand, which I have not even seen a whiff of yet. So on June 9th of 2022, a Norfolk County grand jury indicted the defendant on charges of red rum in the second degree, manslaughter while operating under the influence of alcohol, and leaving the scene of personal injury and death. On October 5 of 2022, this court issued an order directing the Commonwealth to provide the defense with, inter alia, all crime scene photographs and or videos taken in connection with this case, including but not limited to photographs documenting the purported recovery of pieces of white and red plastic outside the residence located at 34 Fairview Road on January 29 of 2022 and February 4 of 2022, including the metadata associated with these photographs and videos. Several months later, and then they cite Exhibit B of the defendant's motion. Several months later, in June of 2023, Proctor asked CPD whether it had in its possession any exterior Sally Port video showing the defendant's vehicle on the flatbed of the tow truck on January 29th of 2022. Footnote 3, it is unclear to the court why Trooper Proctor, former Trooper Proctor, requested the footage at this time. It is unclear, Judge Bev. In response, CPD gave state police the video from the main driveway side exterior Sallyport camera. Proctor took possession of this video, but again, for reasons unexplained, did not turn it over to the prosecutors. Instead, he placed it in his case file. This footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage. The recording is dark, blurry, and grainy, and the condition of the passenger side taillight, a significant issue in dispute in this case, cannot be discerned. On February 1, 2024, Proctor testified before a federal grand jury investigating the investigation into O'Keefe's death, redacted. 3 months later, on April 4th, 2024, ADA Adam Lally received Proctor's federal grand jury testimony. After reading Proctor's testimony, Lally said, "Wow, whoa, there's video?" Lally asked Trooper if he was in possession of the video footage referenced therein. In response, Proctor gave Lally the Sallyport front wall camera footage provided to Proctor in February of 2022, but not the main driveway side exterior Sallyport footage provided to Proctor in June of 2023. Lally immediately turned over the Sallyport front wall camera footage to the defense, along with the footage from the CPD main driveway, showing the SUV on the flatbed. Footnote 4. It is unclear to the court where the CPD main driveway footage came from. The CPD main driveway camera appears to show a different view than the main driveway side exterior camera. The recording from the camera remained in Trooper Proctor's file. Former Trooper Proctor.
And when Lally immediately turned this over, did he disclose the fact that it was inverted? Did he say we had some issues with our cameras and the video is inverted? I wonder if he did anything like that. Did he, Bob?
I don't know, babe.
No.
I don't know.
He didn't.
No, I don't think he did, babe. So none of this footage contained a view of the back of the defendant's SUV. On April 10th of 2024, Lally filed a certificate of compliance indicating that, to the best of the Commonwealth's knowledge, and after reasonable inquiry, it had disclosed and made available all items subject to discovery pursuant to Mass Rule of Criminal Procedure 14, A1A, or court order. So
at that point, the court order said all the video and the metadata.
Right. At that point, that exists in the world. So when the defense counsel reviewed the Sallyport front wall camera footage, they saw that 42 minutes of footage was missing. The defense raised the issue to the court at a hearing on April 12th, 2024, days before the trial was set to begin, arguing that the missing footage was critical to the defense's theory. The Commonwealth explained that the footage was intermittent because the camera was motion activated.
Where's her footnote? Where's her footnote that I noted movement during all periods when this 42-minute, missing footage? They did.
Yeah, whereas Zianetti said, the car, the vehicle driving into the Sallyport is the definition of movement. How do we not see that? People walking around is the definition of movement.
But right, the car entering the Sallyport is definition of movement.
Trial began on April 16th of 2024 with the first day of evidence on April 29th of 2024. On April 17th, 2024, Lally received footage of the Sallyport interior back wall camera from the CPD, which had been looking for continuous camera footage of the Sallyport on the relevant date. Is there some word missing there?
I think it's saying that
from the CPD, which had been looking for continuous camera footage of the cell. Oh, I think they're talking about the CPD was looking for it. So on April 23rd of 2024, Lally provided the Sallyport interior back wall footage to the defense. The images contained in this footage were inverted. State Police Sergeant Buchanan testified on June 5 and 6, 2024. During his direct examination, Lally showed the inverted Sallyport interior back wall footage in open court. Because the video was inverted, what happened on screen as the right side of the vehicle was in fact the left side and vice versa. The direct testimony did not alert the jury that the video was inverted. Wow. What a way to soft pedal that shit.
Right. The direct
way
testimony did not alert the jury the video was inverted. No, he specifically elicited testimony that inferred that it was, and I believe it. He asked if it truly and accurately depict the scene, and if he didn't, if I'm wrong, and he didn't, that is standard black letter direct examination, laying foundation for any image. His failure to have done that would be indicative of his knowledge in the first place. But I
did
think
it.
he did do it.
He did do it.
So yeah, soft pedal is right.
The direct testimony did not alert the jury that the video was inverted. On cross-examination, however, defense counsel questioned Buchanan extensively about the inverted image. The CPD began, see, that's not a remedy. So essentially what happened here is because the defense caught it and brought it up on cross, they're being punished. So had they not caught it, had this trial gone through, had Karen Reed been convicted, at that point, you're going through direct appeal. And then at some point down the road, they figure out that it was inverted and they used it. Is that the only time in which she gets a retrial?
That's what she's saying. That's what Judge Cannone is saying the appropriate remedy would be in this situation, that her conviction would have been reversed and she would have been granted a new trial.
It's crazy. So the CPD began a review of other video surveillance footage in an attempt to explain the inverted image and respond to allegations that it had deliberately manipulated the recording. As a part of this process, CPD Chief Rafferty reviewed surveillance footage from cameras in the hallways and the parking lot at the CPD in the early morning hours of January 29, 2022, prior to O'Keefe being discovered in the snow. How do we know that? Where's the proof of that? Because she said so. Aren't we past the point yet that we don't believe a goddamn word these people say? I mean, how much shit do they have to pull?
And let me ask you this.
How much shit do they have to pull before this judge realizes that this entire police force is corrupt as shit? How much do they have to do? Like, what do they need to do before Cannone, who sits in that county, who deals with these cops all the time, before she realizes, okay, you know what? I can't take them at their word. It happens. In Baltimore, after the gun trace task force bullshit, they would not put cops on the stand because they were all full of shit. They had zero credibility. They had zero credibility.
What and how does she write the words in good faith? She writes the words. The Canton Police Department began a review of other video surveillance footage in an attempt to explain the inverted image. What? Wait a minute. I thought they had to have the cameras repaired. I thought they were fully aware of this problem's existence. They realized it happened. They had to have the cameras replaced or fixed or something. Why does she think that they needed to attempt to explain the inverted image if she believes their factual assertions, so-called factual, ipsy dixit factual, because Brennan said so, that you know, the cameras, there was an issue with the cameras. They had to replace them. They had to fix them. So why would they be trying to figure it out? You can't tell me that since 2021 until 2024, they had inverted cameras all that time.
Yeah, not one genius cop in that entire department ever realized, hey, man, this shit's inverted. Like in all the evidence that they handed over in all the cases, not one prosecutor at that prosecutor's office is like, hey, man, this shit seems inverted. What's going on with the video coming from? Like, are we supposed to believe that took place? Because I don't believe that took place.
A full hearing on this where witnesses were called to say, when was the cameras fixed? When were they replaced? When did you figure this out? And please produce to me one bit of evidence proving that you produced an inverted video to anyone anytime before January 29th, 2022.
Judge Cannone not only has a duty to the defendant in that courtroom, she has a duty to the citizens of that county. And the citizens of that county do not trust their police force. Is she just blind and deaf to that fact? At the very least, she should have put their feet to a fire with an evidentiary hearing to force them to answer these questions. These are the people that are policing their town. The taxpayers pay their salaries. They deserve answers. This has gotten way past any like, oh, my fault. Sorry, we said it. It's always been backwards. It's always backwards. We don't know how it happened. Bullshit. Put them on the stand. Where's the metadata? Where is the metadata? This thing, like, we don't know where it is. It's up and vanished like a fart in the wind. We don't know where it is. Sorry, that's not an answer. That's not an answer that should satisfy a judge on the bench anywhere in this country. This bullshit with judges protecting the government all the time makes me sick. I'm so sick of it. I cannot stand it. I am I hate that Karen Reed has to be the sacrificial lamb, along with, in my estimation, Richard Allen, to expose the bullshit that's been going on in this country forever with cops and prosecutors. Are there great cops? Of course there are. Are there great prosecutors? Of course there are. Are there shit cops? Of course there are. Are there shit prosecutors? Of course there are. And the problem is, as I've said it a million times, when you have that much power, the damage that you can do in those two positions, prosecutor and cop, is unbelievable.
And the time has come. The time has come for judges, just like we ask jurors, do you tend to find a police officer more believable because they're a police officer? Do you tend to believe the prosecutor more just because he's a prosecutor? It's time judges start acting accordingly and not trust agents of the state just because they're agents of the state. And if this case hasn't proven that to her, as you're stating, what in the hell will?
I mean, if the rest of society no longer thinks that every cop is officer friendly, which we certainly don't en masse. Like I see enough online and on social media and on Twitter, all that shit. I know that there are millions of people in this country that are very, very concerned about the state of policing in this country, the state of the government in this country. And you know what? The way that we can do something, if you're wondering, go vote when your judges are up and do some goddamn research on who's running for judge. That's how we can control this. We actually do have a say-so in this. Get these suckers off the bench. If this is the shit they're going to pull, look, y'all, the reality is prosecutors that is the track to getting on the bench in nearly every county in every state of this country.
What you've got to do in regards to what Bob's saying is, if you know a criminal defense attorney, if you know any attorney, and it's up for, and all the judges are up for re-election, just ask them, is this a fair judge? You know, who should I vote not to be, re-elected, not to stay?
Do a little research.
It's impossible. How do you research unless something dramatic happened? How do you research the kind of rulings to know, are the judges just, haphazardly ignoring the
Well, I mean, if you've got somebody getting on the bench fresh, there's nothing you can do. If they've been on the bench for a hot minute, yeah, you can ask people, right? I mean, if it's a small county,
you got to ask around, though. It's not like check a directory.
For sure. Well, I mean, you can look. There's no one that is elected in Massachusetts. Every single judge is appointed. Well, that's ridiculous. That is terrifying to me.
Is that what one of the?
Yeah, somebody in the chat just said that they're all appointed. Well, every single judge. That is terrifying.
In some of your states, they're not, and you'll
like Illinois. Like some are appointed if somebody retires, midterm, they'll appoint them. But those judges, they got to run for re-election, even if they're initially appointed. Like that's the way it needs to be everywhere. Like those should be elected positions where they can. Where's the accountability if they're appointed? How can we hold them accountable?
Leave them blank. Don't go down the line and just pick Democrat or Republican because they're, what side of the aisle you're on for a judge.
Yeah, judges don't do that.
Leave it blank. And then the people who do know, their vote will count.
100%. In states where I'm still shocked that every single judge in Massachusetts is appointed. That is terrifying.
No
to me.
accountability.
So the rear lot cruiser side camera had recorded ATF agent Brian Higgins, a witness called by the Commonwealth at trial, walking across the parking lot at 1:34 a.m. holding a phone near his face. And
I'm sure she explains that later, why that's important, right?
I don't know. And so in September of 2024, Special Prosecutor Brennan joined the prosecution team. On October 10 of 2024, he provided the rear lot cruiser footage along with the other surveillance video. The CPD interior hallway, the church side exterior sally port, and the rear lot main side to the defense. On November 8th of 2024, the defense emailed Special Prosecutor Brennan requesting, quote, all raw video footage from the CPD, which shall include, but is not limited to, all cameras capturing the interior of the CPD and or exterior of the CPD, including all parking areas, entrances, and exits, and garages between January 29 of 2022 at 12 a.m. and January 29, 2022 at 11:59 p.m. Special Prosecutor Brennan responded that he would request that CPD collect and produce all footage responsive to the request. Oh, what a hero Hank is. What a forthright guy. What a guy Hank Brennan is.
He never mentioned anything about those backup videos in court until he was making the backup files, until he was making his argument.
He's a turncoat. Guy's a mob lawyer, a defense. He's like a through and through defense attorney who's just absolutely turned his back on the defense bar in a way that I can't even imagine somebody doing. What, for 275 grand? He sold his soul to the devil? Get out of here.
He could have done it with integrity.
I mean, I'm not going to even get on it. So thereafter, Brennan asked all associated law enforcement to go through all files and databases to facilitate a review of any footage. Ipsy Dixit, he did. I don't know that. Where's the goddamn proof? Show me an email. Just send an email, Brennan.
She didn't even require a hearing where people took the stand and testimony was given. She didn't even question him under oath.
A damn word they say. Like, honestly, in him more than any of them. He just goes in there and says shit. I mean, I'm getting a shirt made that says, just say shit.
I remember Judge Cannone said to Elise, do you know this of your own personal knowledge? When did she ever ask that question to Brennan? Do you know this of your own personal knowledge? And how?
She never puts it to them ever. Any of them. She didn't do it to Lally. She doesn't do it to Brennan. It's like I honestly try to give judges the benefit of the doubt. I really do. I respect the bench. When I was in court, I always had the highest regard for judges on the bench. I respect the robe. But sitting on this side, I'm allowed to be more critical. Like I'm not in a tie, in a suit in front of the courtroom, having to mince my words, having to keep quiet when I'm getting shit upon. I don't need to do that anymore. So I don't. And what I'm seeing now from the outside looking in is scaring the hell out of me. It was one thing to sit in there and just get the beat down year after year after year after year, as Allison and I have as defense attorneys in this country, as we all do. We take the beatings, we eat it. We eat the shit in court every single day in courtrooms all around the country. And it used to be that all of you guys out there were shitting on us too. So I'm happy to see that that's turned around, that you guys are starting to see what's really, really going on in the courtrooms in this country and who's really protecting your rights. Because it sure the fuck isn't the cops and it sure the fuck isn't the government. It's us, defense attorneys. Please remember that. That is gospel. That's not an opinion. That is a fact. So on January 29th or 28th, 2025, the Commonwealth turned over the main driveway side exterior Sallyport video to the defense. As noted above, the footage shows the exterior of the Sallyport when the defendant's vehicle was brought into the CPD garage, but the quality of the recording is, as noted, poor.
All right. So section B2, the defendant's arguments. Give me 1 second.
Okay.
Defendant's arguments. The defendant argues that the Commonwealth provided an untimely disclosure, withheld or destroyed certain CPD surveillance video in violation of Rule 14, Brady, and the court's preservation order and October 5th, 2022 order on motion to compel discovery. She further contends that the timing and quality of the video footage that has been produced demonstrates that the Commonwealth sought to intentionally deprive the defendant of exculpatory evidence. According to the defendant, the Commonwealth's conduct was so egregious that dismissal is warranted. This argument is flawed in several respects.
No, it's not.
And she leaves out that they misled the jury.
She doesn't care. She does. As a sitting judge, she should be outraged that they put some bullshit on in that courtroom. And like this plausible deniability shit's gonna, like, she's cool with it. Shame on her. Shame on her.
First, contrary to the defendant's argument, there was no court order requiring the Commonwealth to preserve or produce the CPD surveillance video before the first trial. The February 2nd, 2022 preservation order required the Commonwealth to preserve all physical evidence, including anything present on or near the decedent at the time his body was discovered, anything found at the alleged crime scene. And she cites Defendant's Exhibit A at paragraph 6. This order did not extend to the surveillance footage from the CPD. Massachusetts case law reflects a clear distinction between physical evidence and video surveillance footage.
Yes? What are you doing? You're muted.
I was
Damn
caught.
it, I got to get that thing ready for those glorious times where you mute yourself.
All right, so let me say that again. This order did not extend to the surveillance footage from the CPD. Massachusetts case law reflects a clear distinction between, quote, physical evidence, end quote, and video surveillance footage. She cites Commonwealth v. Vasquez, a 2025 case, for the proposition that, quote, as no physical evidence connected to the defendant to the crime, the Commonwealth relied on the surveillance video to prove the defendant's identity as the shooter. She cites to Commonwealth v. Harrison, a 2022 case, characterizing evidence against the defendant as, quote, communication, surveillance, and physical evidence. She cites Commonwealth v. Flavel, a 2024 case. The Commonwealth's evidence included numerous witnesses, including the victim and expert witnesses, as well as physical evidence, surveillance video, and photographs. Commonwealth v. Lattimore, 2016 case. Based upon witness interviews, physical evidence, and video surveillance footage, police determined that two suspects had entered the store and opened fire. Moreover, where the, quote, physical evidence described in the preservation order was further defined as including anything present on or near decedent at the time his body was discovered and anything found at the alleged crime scene, the order cannot reasonably be interpreted as including surveillance footage from the police station. How is that further defined as including? That is additionally specifying that it also includes. It doesn't limit the definition of physical evidence. They're just also making clear that this extends to anything present or near the decedent at the time his body was discovered and anything found in the alleged crime scene. It doesn't limit the definition of physical evidence otherwise. The October 5th, 2022 order on the motion to compel discovery also did not require the Commonwealth to produce any CPD surveillance video to the defense. That order required the prosecution to produce evidence of, quote, all crime scene photographs and or video taken in connection with this case. So those are two different things. All crime scene photographs and or video taken in connection with this case. And or video taken in connection with this case. The CPD was not part of the crime scene, and therefore the order did not compel production of the CPD videos.
The hell it wasn't. The hell it was. All right, so this got me furious. So I would argue that a vehicle is a location, not a thing. If you were prosecuting an SA case, say a violent SA case, and it happened in a motor vehicle, where is the crime scene?
The motor vehicle.
The motor vehicle. And in this case, that implement, the vehicle itself, is definitely the crime scene. It is a part of the crime scene. As a matter of fact, the crime scene isn't the yard, according to their theory. The crime scene is the vehicle, because that's where it happened. So wherever that car moved, wherever that Lexus went, that became the crime scene. So if they're keeping the vehicle in the Sally Port, you know what? CPD is the crime scene, because the vehicle is the crime scene. It's a bullshit thing that she did here. And yes.
No, I was just going to say, even above that, it says and or videos taken in connection with this case.
Yeah, I understand that. I was going up to the first part.
I know. I mean, even if your argument is, well, I absolutely agree that the weapon, is a part of the crime scene when it's a
but more than that, it's a location. Like, you can't be in a knife, but you can be in a car. So
well, but it wasn't in a car. I mean, let's be real.
It was on the car.
Just like it's by a knife.
On the car. The car is a place, right? I mean, it's a place that you can be. If it's moving, you could be in a car that's in a place at different places, but you're still in a place. It's not an object like a knife is. Vehicles certainly are crime scenes. Right. If the vehicle's involved. I mean, many times if it's an SA in a vehicle, that is it. That is the entire crime scene.
Well, but that is in a vehicle.
Don't mince words. That's bullshit. My point is that the car is the implement that they're saying, and they're saying that the car is what caused the death. That is the crime scene.
It's the murder weapon.
It's the crime scene. It is the crime scene. It's more the crime scene than the front yard is, I would argue. It wouldn't have mattered where it happened.
I agree.
No matter where it happened, whether it was at 34 Fairview or on the moon, the vehicle hitting John O'Keefe is their theory, and that becomes the crime scene, because that is where you're pulling your evidence from.
Exactly. That is
unless they plant it in the front yard, and then you pull it from there too.
Right. But that is the point, that evidence on that vehicle was critical to proving guilt or innocence. It contains exculpatory or inculpatory evidence. So that is of the utmost importance to be preserved. And in any situation where they're saying the car is a murder weapon and that the condition of the car proves that, which they were saying from the jump, then how in the hell is that not critical evidence that needs to be documented and turned over? And we'll see how the court addresses that in the following paragraphs here.
I just don't like that she's being slippery in the language. You shouldn't be on Team Alley. You should have said, oh, you know what? And it's not Team Alley or Team Bob on this, because we're saying the same things with a few alterations. My point being is that she shouldn't be able to say that the original protective order or whatever they put in, production order, or what was it?
Yeah, production order, discovery order.
No, it was the order to preserve, preservation order. So that order did not include the crime scene, because she doesn't consider the vehicle to be a crime scene. You guys should want that to be part of the crime scene, because then she's not able to weasel out of it by saying that the original protective order didn't protect those videos and that they weren't included within it. They certainly were. You know, I mean, as defense attorneys, we can't know something exists until we know it exists. Like if these guys have been trying a shit ton of cases over in Canton, they'd be like, all right, well, where's the Sally Port stuff? If they know there's a car involved, they're immediately asking for it because they know it exists. They know they have video because they get it all the time from them in various cases. If they're trying to look and see what the condition of cars are and they ask for it in other cases, I don't know how many cases Yanetti's tried in Dedham. Like, I don't know if he's like completely in tune with what they have in terms of evidence typically being turned over in that particular county. So, I mean, like in our counties, we know what videos they have. We know where we can get videos from. I mean, shit, these days there's videos everywhere. And everybody knows that every portion of a cop shop has video.
And the court recognizes in the next paragraph that that's not the end of the inquiry. The judge writes, this is not the end of the inquiry, however. The absence of a court order requiring production of the CPD surveillance does not foreclose the possibility that production may still have been required under Brady and or Rule 14. The defendant contends that the prosecution should have inquired of the CPD if any footage existed and then produced all footage because she maintains that it contains exculpatory evidence. Let's just start right there. Who in the hell doesn't think the prosecutor in this county knows that there's video in the Sally Port? What do you mean? That they've got to like inquire? Is
Hank Brennan doesn't.
Lally does.
Lally knows.
Lally does. McLaughlin, is that her name?
Yeah, she
McLaughlin knows.
The cops know.
Right.
And we went through this in terms of their motion to dismiss. This all extends to the cops. They are arms of the prosecutor. The same exact things in terms of what has to be turned over extend out to law enforcement. We read the rule directly from the rule. They cited it. Like the cops count. Her putting it on Proctor is not a safe harbor for her. Nope. It's not. Her saying for reasons unknown, for reasons unexplained, Proctor held on to all this shit. Well, tough shit. He is them. He's the government.
Yep. She continues to write, the defendant contends that the prosecution should have inquired of the CPD footage, if any existed, and then produced all footage because she maintains that it contains exculpatory evidence. Specifically, the defendant argues that the footage shows Proctor approaching the taillight in a manner that she says supports an argument that he tampered with the evidence. Assuming, without deciding, that the footage is actually useful to the defense, dismissal is not warranted because defense counsel actually used this evidence to advance the tampering theory at the first trial and can do so again at the retrial. This misstates the point. The judge is overlooking the point that although he can make some inference, and he was able to make that inference that there could have been tampering there, when you don't have all of it, their argument is with all of it, we could have actually shown it. It could have actually been shown. Moving on. In addition, while the current Rule 14 makes clear that the Commonwealth is required to disclose the defense as investigative materials, video and audio recordings in possession, custody, or control of any member of the prosecuting team, the Rule 14 in effect at the relevant time had no such requirement. What about Brady, Judge Cannone? What about Brady and its progeny? Nor did Rule 14 in effect at the time clearly state the prosecutor's duty to inquire whether such evidence exists. Footnote 5, in this regard, the Standing Advisory Committee proposed a revision of Rule 14, which the Supreme Judicial Court adopted. The revised Rule 14 devotes a section to, quote, the prosecutor's duty to inform and inquire, collect and disclose, preserve and notify, and record items that are subject to these rules. Again, it is my position that the amendment of their Rule 14 just puts into play all of the requirements that have been developed over the years, even through the federal courts, as to the, again, the federal sets the lowest bar of what needs to be done, that is just a recitation of the actual law. They're not making a new law by that rule. The rule is reflecting the current state of the law and making it explicit. Moving on. The defendant made no specific request.
Continuing.
Defendant, the court further writes, because the defendant made no specific request for the Commonwealth to produce such evidence until after the first trial, it is not clear on the record how or when the Commonwealth should have known that the surveillance video was germane to the defense. Again, how can she write this with a straight face? How could she type the words onto paper or direct someone to type the words onto paper? Lally and McLaughlin clearly know there is surveillance in the Sallyport, and there is no question. It is without question that the murder weapon is germane to the defense. Period. Until the Commonwealth knew, for example, that the defense theory included that law enforcement tampered with the taillight while it was at the Sallyport, or that Higgins was the proposed third-party culprit, it had no reason to inquire as to whether any relevant footage existed. Now, before we get to 6 and 7, I'm just going to say this again, that I don't understand how a car is supposed to have hit somebody and the condition of that car is not germane, is not important, does not have evidence of either guilt or innocence. It is all has to be turned over. So she's got 2 footnotes here, starting with 6. Defendant also argues that the rear lot cruiser side camera footage should have been turned over because it was exculpatory impeachment evidence that the defense could have used to show that Higgins, quote, perjured himself before the federal grand jury when he testified he did not call anyone on the night in question. Defendant's memorandum at 20, she's citing. The argument fails for several reasons. First, it is not at all clear how, within the boundaries of admissible evidence, the defendant could introduce evidence of this alleged perjury at her criminal trial. Say what? Say what? I don't understand what she is talking about. It is without question, I'm going to say again, that if someone perjured themselves in another trial, that is always relevant on cross-examination. It goes to the trustworthiness of the witness. That is an absurd proposition. Absurd proposition. Now, we do, is it proving up an impeachment with collateral evidence? So that's a different proposition where, well, you can ask them, did you testify this way? But weren't you on this video? But if they say no, I wasn't on video doing that, then the question becomes, can you prove up that impeachment by what's called collateral evidence? And typically you cannot. You have to let them stand on their druthers. But still, within the bounds of admissible evidence, it's called cross-examination. It's the whole basis of cross-examination. Any untruthfulness is relevant on cross-examination, especially a prior perjured testimony.
The credibility of the witness is the entire point. Determining if they're credible or not. That is the entire point of cross-examination. Like, it's the only way we know if somebody's full of shit on the stand. It's the only way that you can attack somebody's credibility. You have to test it. Otherwise, people just get up there and say shit. Hank Brennan style. Whatever. I've seen people that I always was of the mindset, you know what? When people get into the trappings of the court and they feel the tension in that room, they're not going to be able to help themselves but tell the truth. I learned very, very early on in my career that was absolute bullshit. People that are just professional liars can get up there and lie without blinking an eye. It's insane. So, the only way that we can ever challenge somebody's credibility is exactly what Allison's talking about. It's the entire point of cross-examination. It's why we have that Sixth Amendment right. It's a confrontation clause, baby.
Yes, it is. Second, even a cursory review of Higgins' grand jury testimony reveals that he said that extracted. Now, I'm just going to make an assumption here that whatever he said, she's saying was less definitive than I absolutely did not make a phone call. But we don't know because it's not in there. Third, the video at issue, a 4-second silent clip showing Higgins walking across the parking lot holding a phone near his face, does not, quote, clearly show, as the defendant represents, the witness, quote, speaking to some unidentified individual on the phone. What? All right. The clip does not reveal how Higgins is utilizing the device, and it in no way establishes that he perjured himself before the federal grand jury.
He was warming his face with his phone. He was chilly. He was just warming his face with it. What kind of jerk off?
I mean,
in this day and age, puts their phone to their ear anyway.
Right. We all know when you're looking at your phone, it's sort of like here. You know, it's out further away. When it's like here, you're talking to someone on it.
Yeah, like I'll put it out here, with
Right.
my
But when I'm looking at it, it's got to be, down. My head's down. It's
if
down.
I'm FaceTiming somebody, it's right here.
What am I searching on my phone like this? Come on, Judge Cannone. Let's be serious. Finally, in this regard, the remedy for non-production of this video clip is not dismissal because the defendant's rights are fully protected by her ability to use it for all it's worth at the retrial. And then footnote 7 says, with respect to the main driveway side exterior Sallyport camera, even if Proctor should have turned it over to Lally, even if Proctor should have turned it over to Lally prior to trial, the quality of the footage is so poor that it is impossible to tell the condition of the taillight or how close anyone was to the right taillight. To the extent that the defendant contends that the footage could have been used to impeach Buchanan's testimony, she will have that opportunity at the retrial.
Bukkake.
You like that soundbite now, don't you?
Moving back to the body of the...
Wow, Mandy's really...
moving back to the body of the judge's order, this is not to say that the Commonwealth had no duty to turn over the Sallyport interior back wall footage before the first trial. The production during trial was undoubtedly late. However, the defendant received the video more than a month before it was submitted into evidence, and because she had advanced no argument as to what, if anything, her counsel would have done differently if the disclosure had come earlier, the defendant has not shown she was prejudiced as a result of the late disclosure. And they cite a 2010 case for the proposition that in determining the consequences of late disclosure, we ask whether the defense was materially hurt in its preparation by having to meet the unexpected evidence. She also quotes a 1996 case where the court held the trial court properly denied a motion to dismiss for delayed disclosure where the defendant failed to show any prejudice would occur as a result. All right. What's the one word we need to say right here, Bob?
What do you mean?
Metadata. Metadata, Judge Cannone. Metadata. That's what she'd have that she doesn't have, that she can't have, that is not replaceable. Judge Cannone cites a 2021 Massachusetts case for the proposition that a defendant made the requisite showing of prejudice. Here you go, babe. The requisite showing of prejudice by detailing the manner in which, had he been informed timely of the witness's statements, he would have altered his defense tactics to undermine the veracity of the statements. Footnote 8. Moreover, during cross-examination, Jackson questioned Buchanan extensively about the video being inverted and even played a corrected version of the video that was not inverted, leaving no doubt in the minds of the jurors that the video played by the Commonwealth was not a fair and accurate depiction of what occurred inside the Sallyport. Thus, the disclosure was sufficiently timely to allow the defendant to make effective use of the evidence in preparing and presenting her case. Bullshit. Just because he effectively used it in one sense doesn't take away all the other possible effective uses that could have been made with the metadata, with the other, with time to determine what the condition of the cameras were at what given dates, and all of these other things. Like, no, just because she made one effective use of it, and yeah, they did make an effective use of it, that doesn't mean it's the only
Kind
effective
of.
use.
Kind of.
Right.
Like it wasn't so effective that the jurors weren't all outraged that the Commonwealth wasn't trying to pull the wool over their eyes. Like if the jurors, if it would have hit home like it should have, it's not guilty. They're like, we can't trust these sons of bitches. You see the shit they did with the Sally Port video? They're all full of shit.
Right. It should say,
I'm
because
telling you, the defense was punished because they figured it out.
Because the defense did the best they could with the shit they were given. She wasn't denied her constitutional right to a fair trial, because she did the best that could have been done with the shit evidence that she was given.
See, I knew she was going to say this shit too, that the remedy was going to be that she's getting a retrial. That is not the teeth that you're looking for. There's no teeth to that. She was getting a retrial anyway because they couldn't prove up their goddamn case the first time. She's done nothing here.
That's a very good point, Bob. And that point shouldn't be lost on you guys. When they give someone a new trial, yeah, that is to right the wrong that was actually done to that defendant. But it also, as Bob's saying, is kind of teeth to the prosecution. You screw up like this, somebody's getting a new trial. And that there is no part of that deterrent here because she was already getting the new trial. So Bob's point is very important, because part of the analysis and the point of the remedy is not just to right the wrong the defendant encountered, but to deter the police and the prosecution from letting something like this ever happen again.
Well, and that's why I was saying all the way back when we read the motion to dismiss, the retrial, there is no remedy to it. Her getting something that she's doing anyway, that she has to do because it was a mistrial, that's not a remedy. That there is no punishment being meted out to the prosecution, to the government, for the bullshit they're pulling. Like, I mean, people should be outraged by this. It's disgusting. It's like, I don't know what other lawyers are doing, but Allie and I are, I mean, we've been in criminal defense courts forever, so we've been seeing this shit forever. It's like maybe civil attorneys aren't as quite as outraged, but they should be. This shit cannot go on in our courtrooms in this country. We can't allow for it. It's so scary. I mean, you see it in real time. Imagine if Karen Reed didn't have the money to hire these guys the first time. Imagine what a railroad job this would have been. Just try to think of that for a minute. And then that's the rest of the country. That's what everybody else that's in courtrooms, with a small exception of people that have money to hire lawyers of this quality to go in and fight like this. Imagine that. I just want you to think for 1 minute, if she didn't have the funds to go and hire 3 powerhouse attorneys or 2 powerhouse attorneys, whatever the fact may be, that she would have been railroaded from here to kingdom come. She would have been convicted of the murder and the first trial
murder, right?
If she didn't have this defense. That should scare the shit out of everybody. Scares the shit out of me.
Did Manny just give us Pac-Man?
It was like, I think, a game over thing. Game over.
Oh, it sounded like the Pac-Man game over, like when they're dying. That is, the court goes on to say, that is, the defendant must establish a reasonable possibility that the lost or destroyed evidence was in fact exculpatory. So, I mean, that's next to impossible here, because they didn't produce all the video. We can't get the full video and the condition of the video. So
oh my God.
It seems the judge doesn't take any issue with the possibility that she doesn't mention why they said it was missing 42 minutes before, why there's still no video of it pulling into the
I can't
Sally
even
Port.
handle the next two paragraphs with the metadata shit. Like, is she kidding me? She doesn't give a shit about a chain of custody. Like, as far as video and digital evidence, metadata is everything. It is the chain of custody. It's the exact equivalent of a evidence tech following a guy around a room when they're collecting evidence and keeping track of who found what, where they found it, when they bagged it, where they sent it. It's the exact same goddamn thing.
Right. And well, let me read that paragraph. Lastly, as to this claim, to the extent the defendant claims, I mean, are we unclear that the defendant actually claimed this? That's typically those words are like, to the extent the defendant claims. It's like, this claim hasn't really been said, but they kind of may have said it. So I'm going to say to the extent the defendant claims. Anyway, lastly, as to this claim, to the extent that the defendant claims to have rights based upon the Commonwealth's handling of metadata, she will have the opportunity to seek redress in the context of the retrial. What? Of metadata she doesn't have? Of backup files that they just said they found but still didn't produce the metadata? I'm going to be really pissed if the defense has not gone back out, and it doesn't sound like they have, because I didn't see any new witnesses listed, and examined that thing for the other video that Lally played at this hearing showing, it was inverted before. Where's the metadata for that one? Where's the metadata for that one?
Where's the metadata for all of it?
They can put it back in its native form. I mean, I literally just had to send an email on one of my cases, and the lawyer sent back and said, can you send it in the native form? And I was like, I got to figure out how to send it in the native form. And the reason they do that is because then it has all the metadata to make sure I didn't just change something in the email that I'm forwarding them, that's the way it was on the date that I sent it. So I had to extract it and then, send it over as a separate file. And they could do that because they have the software that their videos ran through. So I don't understand why they can't get the metadata now. I don't understand why it's limited to the device, but there was reference to backup files. And somehow, some way, Lally found that other video of another case showing it was inverted before. All of a sudden, nothing's deleted in 30 days. It's all on the backup file.
She is acting as the trier of fact here. Like, it's crazy to me. Like she's like an absolute apologist for the Commonwealth. She's putting in facts that Brennan never even said. She's gone like above and beyond to make excuses for the Commonwealth. It's insane.
And that appears to be the end of what we all is very clearly the most egregious act here. That's it. So I guess
now we're going to get to her excuses for Jen McCabe, and I'm assuming she's going to shit all over the juror thing, right? I mean,
right. So all my holding out hope that maybe she was going to become strong-armed with them. She was going to say how wrong it was, even if she's doing it apologetically. But they can't allow this to happen. This was a horrible oversight. But it was, like something,
anything,
nothing,
anything acknowledging that the Commonwealth can't do this shit. Not in my courtroom.
Right. It appears
you're lucky that she's getting a retrial, because otherwise I would have tossed this case. Something like that. Anything.
And
we got nothing.
Nothing.
That's what we got, was nothing. All right. C, withholding.
What she spends the next, 14 pages on.
C, withholding of exculpatory statement by Jennifer McCabe. I, factual background on May 7th, 2024, during the first trial. The defense produced reciprocal discovery to the Commonwealth regarding the location information of witness Jennifer McCabe's cell phone. The location data showed that on January 30th, 2022, McCabe went to the home of Canton Police Sergeant Michael Lank, who was one of the first police officers to arrive at the scene on the morning of January 29th of 2022. In anticipation of her trial testimony, the Commonwealth met with McCabe. Lally, ADA McLaughlin, and MSP Lieutenant Brian Tully were present. Tully asked McCabe why her cell phone would have been in the area of Lank's house on January 30th of 2024. McCabe said she was with Carrie Roberts, who was picking up her daughter at the residence, and she did not speak with Lank while there. The Commonwealth did not turn over the substance of this conversation to the defense prior to McCabe taking the witness stand. Tully wrote a brief report on the meeting, but it was not produced to the defense until May 29th of 2024. On May 21 of 2024, Attorney Jackson cross-examined McCabe on behalf of the defense. He asked McCabe if anything significant happened on January 30th of 2022. And she explained that she went to Lank's house with Roberts to drop off Roberts' daughter, and Lank's wife came out of the house to talk to them. Jackson questioned McCabe as to why she did not report the fact that she had met with, quote, one of the first responding officers on the case working for the Canton PD, which is conflicted off of the case, end quote. He further questioned her on the length of the conversation, who else she talked to at the house, and where she was during the conversation, if she went into the house. During cross-examination, Jackson also asked or questioned McCabe about the details of her discussions with Lally, McLaughlin, and Tully about her trip to Lank's house. She testified that when Tully asked her if she went to Lank's house on January 30th, 2022, quote, "At first I said, no, I've never been to his house. Then I thought about it and I said, oh my gosh, yes, I did go there." And that was the extent of the conversation. On June 18th of 2024, after the defense received Tully's report of his meeting with McCabe, Jackson raised the issue of the Commonwealth's failure to disclose McCabe's statements during the meeting prior to her testimony. Quote, during trial, the Commonwealth interviewed Jen McCabe, apparently had a full interview with her. Lieutenant Tully took a report, dated the report, and then the Commonwealth held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony, end quote. The court offered to allow Jackson to call McCabe back to the witness stand, and Jackson declined, saying, no, Your Honor, that's not my, and I think the court understands, that's not my point. My point is not that I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. When the court asked, you've what? Jackson repeated, I've done the damage that needs to be done on Jennifer McCabe, and stated, I don't need to call her back.
So she's like relying on that. Again, I'm waiting for her to take the opportunity to say what an egregious discovery violation
She just wants to
was.
cherry pick all the defense's shit.
No, but
she
that's
remembers everything the defense says, but doesn't remember a goddamn thing that the Commonwealth says ever. She's got all the defense shit committed to memory. As far as the Commonwealth, though, they're good. They're good.
Every witness statement, every statement of a witness before you put them on the stand must be turned over to the defense. That is, again, without question. Now, again, I do agree with Judge Cannone that for that late disclosure, there's no prejudice on retrial. But should it have been taken in compilation with the inverted video to show that it's intentional, deliberate, maybe, but that can be remedied. There is no prejudice at a retrial from this.
It's your turn.
It's my turn.
It's your turn. You're up.
All right. Subsection 2, defendant's argument. The defendant argues, in violation of Brady and Rule 14, the Commonwealth withheld the May 10th, 2024 false statement given to by McCabe to Tully regarding her visit to Lank's house, which defendant claims could have been used to impeach McCabe. The version of Rule 14 then in effect required that the, quote, statements of persons the party intends to call as witnesses are subject to automatic disclosure. The Commonwealth, therefore, should have provided McCabe's statement to the defendant after meeting with her and certainly before her testimony. However, the defendant cannot reasonably claim that she suffered any prejudice as a result of not having McCabe's statement. On cross-examination, Jackson questioned McCabe extensively about what she had told Tully about her visit to Lank's house, why she had not disclosed such events before, and the details of her visit to the house. Moreover, Jackson expressed satisfaction with, quote, the damage he believed he had inflicted on McCabe's credibility. When he declined the court's invitation to recall McCabe to the witness stand in this manner, Jackson undermined any newfound claim of prejudice based on the late disclosure. And once again, the remedy for a violation such as this is not dismissal, especially where, as here, the defendant's rights can be fully protected at the retrial. Subsection D, babe.
Oh, are you reading off me? Oh, okay. D, remedy for discovery violations, as noted repeatedly herein. As noted repeatedly herein, the defendant has not demonstrated that she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. However, even if the defendant were able to show prejudice, the appropriate remedy would not be dismissal of the charges. Dismissal with prejudice is a remedy of the last resort.
So
Under
wait,
the
let's just circle back. She says, has not demonstrated she suffered any actual prejudice based on the Commonwealth's late disclosure or failure to disclose evidence before the first trial. So that's going back to what she was saying before. So remember earlier I made the point that, okay, she's saying she can't show that there'll be prejudice that can't be remedied in the second trial. But now she's going as far as saying again, there was no prejudice at the first trial. That is absurd. It's one thing to say there was some prejudice, but the remedy is, a second trial. It's another to say there was no prejudice at all.
It's crazy. The thing that you need to think about is the fact that when they get these late disclosures, the defense can't file pretrial motions regarding them if there's issues that are made apparent in that discovery that should have been tendered in a timely fashion. Like how do you remedy that? Like what happens if something gets waived because you didn't bring it up pre-trial in a motion because they didn't tender the discovery late? So then you're having to argue, you're having to go all the way back that they didn't turn it over timely. That's why we didn't address it.
The remedy is retrial. The remedy is retrial.
Maybe.
I mean, that's the remedy offered for late disclosure and non-disclosure, both. But to say she didn't suffer any prejudice at the first trial, it is just so disingenuous. It's absurd. Why can't she just say that there was some prejudice and the remedy is retrial? She has to go as far as saying there was none, but even if there was, the remedy is retrial.
Was I reading?
Yep.
Oh, under the circumstances of this case, where there was a mistrial and the defendant now has the evidence at issue prior to the second trial, she cannot show that she suffered an irremediable harm to her opportunity to obtain a fair trial. Kronk. Sanctions must be remedial rather than punitive in nature, aimed at curing any prejudice caused by the violation of a discovery obligation and ensuring a fair trial. Dismissal with prejudice is too drastic a remedy if the error can be remedied and the defendant can still obtain a fair trial. Indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not dismissal of the charges. Different circumstances, though. Like she's conflating the fact that this was a mistrial, and she's acting as if she has won an appeal and has been granted a new trial. They're two completely different things. She's reading cases that aren't relating back to something such as a retrial because there was a mistrial. These cases are all about people that were convicted. Every time you're reading case law, there's been somebody convicted. Like
exactly.
That's where this law comes from. So these people are all people that were in prison fighting to say, hey, I didn't get a fair trial, and this is what happened. Please, appellate court, give me a new trial. Okay, you get a new trial. You're right. You were prejudiced. This is how we're going to fix it. You're right. They did turn over the shit late. We're going to give you a new trial. It's a different circumstance. It's a completely different circumstance.
Again, because the fact that they have to retry it is what, is the teeth, and she's ignoring the deterrent aspect of this that she said is reserved in the most egregious cases where they need to deter the conduct so it doesn't reoccur.
So, if the error can be remedied and the defendant can still obtain a fair trial, indeed, even in cases where the withholding of evidence is brought to light after a conviction, the remedy is most often a new trial, not dismissal of the charges. New trial order we're prosecuting, but like we're just not in that position. We're just not in that position. You know what I mean? It's like
Yeah.
it's not the same set of circumstances.
So tell us on Donahue, which is 1986, what did happen there?
Oh, okay. Thanks, babe. So, new trial ordered where prosecutor failed to pass along defense counsel's request to federal authorities for FBI investigative reports that were later revealed to support defendant's alibi defense. So, the new trial, and that was Commonwealth v. Buck, which stands for the proposition new trial warranted where prosecutor failed to disclose complete surveillance videotape, which would have supported the defendant's alibi. And then finally, you've got.
But wait a minute. I need that case, that Buck case, to say they failed to disclose complete surveillance videotape, which would have supported the defendant's alibi, and produced to the jury a misleading and false videotape that discredited her alibi. That is a comparable case. That that would be comparable, and I guarantee they'd be talking about the deterrent effect there.
100%. So, dismissal appropriate where defendant was prejudiced by the government's deliberate refusal to produce court order of discovery. So, nor has the defendant shown the Commonwealth's conduct was so egregious, deliberate, and intentional that prejudice should be presumed.
Oh,
Such a
my
theory
Lord.
shouldn't
What?
be
Sorry.
should be narrowly vent, girl. Such a theory should be narrowly applied and confined to situations where the misconduct has cast such doubt as to poison the entire investigation, and a stronger deterrent is warranted to prevent repetition of such misconduct. She doubled down on it. She doubled down on that quote from that citation from that case right there is what she should have used when she was dismissing the case. That exact language right there. That's what she plucks in. I had no choice. You left me no choice. You left me no choice but to do this.
Or at least laying down a heavy hand that she's about to.
Yeah, like she did with Jackson the other day.
Right.
Put the fear of God in him. Have the meeting, the sidebar in the corner. Oh, you come back to the bench. Who's lead counsel?
Oh my God,
Mr.
the next
Yannetti, are
sentence.
you lead counsel? You know, that whole thing. Only to, putting everybody at that table like, oh my God, she's about to kick Jackson off the case, only to turn around and say, well, Miss Reed, she was adamant that she wants you as the attorney, so I'm not gonna pull your pro hoc.
This next sentence makes me want to pull my hair out. It makes me want to scream so loud.
What's stopping you?
Well, read it
It's
first.
our channel. You can do whatever you want. The facts, just turn your mic down a little bit, maybe. The facts before the court do not depict a concerted and intentional attempt by the prosecution team to deprive the defendant of discovery, which would have aided her case.
Well, but do they show a concerted and intentional attempt to mislead the jury? Do they not show a concerted and intentional attempt? And why the hell is she writing by the prosecution team? Why is she writing that? This is a Brady violation. This is by Commonwealth actors, by the police department, by Proctor, by whoever the hell had anything to do with that video being recorded, known, delivered. There's a person that's responsible for making sure all evidence gets over to the prosecution. That person knows, either by an actual checklist or one that is now implanted in their head, Sally Port video. They managed to find the video of Karen when she was being processed, the processing video, the holding cell, whatever. They know it's there. They didn't turn it over. What about that concerted effort? What about that intentional behavior? How in the hell is she just ignoring that? And somebody made this comment earlier, and it was just in the regular comments, so I'm not going to be able to find it again. I put it up there briefly, which was there needed to be a hearing on those videos. There needed to be a hearing. I thought that was a precursor to the motion to dismiss. That was to say whether they're entitled to a hearing, something. To just him to just say a bunch of shit again with no metadata about other videos, and her to not demand to know what other videos from that time frame look like. Okay, Mr. Lally, you mentioned that video. I'm going to need the metadata. I'm going to need some proof that this was tendered to an opposing party, to a court, to somebody before January 21st. How long did this go on? I want every video from that time frame.
All I could say, if it was the defense pulling this shit, they'd be read the riot act. It would be like the world was coming to an end. Not just in this case, in any case. If the defense pulls shit like this, they get flame thrown. Flame thrown. And here, they just get a little pat on the butt. I got you. Don't worry about it, Hanky. I got you.
All right. So people want to know what can be done now. I mean, I don't believe there's anything that could be done. I mean, maybe local residents can write to a judicial oversight committee about Judge Cannone failing to take serious the it's going to go nowhere.
Can they file an interlocutory appeal on this?
No, not that. I don't think so, but I'm not, I'm not the one on the Massachusetts law, but typically the answer to that is no. I wish they would have incorporated this request in with their double jeopardy request and somehow argued that they took all of these steps. I think I mentioned this before, that they did all of this in hopes of getting the defense to seek a mistrial. And because of that, they're barred by double jeopardy from retrial. That it's so egregious that it bars retrial somehow. Because then, and I mentioned this back then when they did it, like I wish they'd throw in some other stuff so that when this appeal goes up, this other issue can be looked at. Like, why didn't they take the time to figure out a way to incorporate it? But no, I don't think I can help your guys' blood pressure go down. I don't, there's, this will all be.
The worst part is that we all knew this was coming, yet we're still all outraged, which is how we're supposed to feel. You're supposed to feel like this.
And I'm just, I'm mostly outraged that she just, like you said, she's making excuses for them.
She's an apologist. She's literally come up with more than Hank has ever said in court. And he said a lot of bullshit. And she's just filled in blanks. It's unbelievable. And it's out there for the world to see. Moving on. Even if the defendant were able to show that the conduct at issue here on the part of the members of the prosecution team was intentional, the remedy would be a new trial with a timely disclosure of the evidence, not dismissal. See Lambhugh. Whether an indictment should be dismissed upon the defendant's motion or the prosecution has acted improperly turns primarily on the ability of the defendant to obtain a fair trial after and in light of the impropriety. In this case, defendant's rights to the disclosure of the evidence pursuant to Brady and the rules of criminal procedure are fully protected because no verdict was returned at the conclusion. How lucky! Karen, you're so lucky! It doesn't matter. You got a new trial.
Did she forget the sentence she wrote just before about something being so outrageous it needs to be deterred so it's not repeated?
She doesn't read that part. That part's invisible to
She
her.
wrote it twice.
It's still, and she doesn't see that part. It's like she's like like law, like constitutional law colorblind or some shit. I don't know. At the conclusion of the first trial, and a retrial is about to start. There you go, champ. You good. She has suffered no irremediable loss of any constitutional right, and her motion for dismissal on these grounds must be denied. Oh, good. You get to read this bullshit with the jury. Quick. I'll be back. There you go. Drink real quick. It's yours, babe.
I know. I'm just, wow. Okay. Oh, I went too far, guys. All right. Subsection 2, Massachusetts State Police interference with the jury. A, factual background. During trial, 2 issues arose with jurors. The first occurred on June 14th, 2024, when one juror, Juror A, reported to the court that another juror, Juror B, had made some comments about the evidence and the defendant. Footnote 9. The court has omitted identifying information about the jurors. Such information is not necessary for the purpose of this decision. And of course, the full record is available for appellate review. This has been done to afford the citizens who served as jurors in this case as much privacy and peace of mind as is allowed by our law. Now she cares about the citizens' peace of mind? Oh, you care about the citizens' peace of mind to know that their law enforcement officers are not getting away with corruption, whatever they want, whenever they want, without so much as a slap on the wrist. Without so much as a slap on the wrist. Returning to the body, the court called Juror B to a sidebar and questioned her about what she had said and if she could keep an open mind and consider the evidence in a fair and impartial manner. Despite her representations that she could, the defense expressed concern that the comments had been one-sided and against the defense and asked that Juror B be excluded. The court then inquired of Juror A. Juror A stated that Juror B had made comments to her about the defendant's facial expressions during trial. The court then questioned 2 other jurors, whom Juror A said were sitting close by when Juror B made the comments. Both jurors stated they had not heard what Juror B said directly, but that Juror A had mentioned it to them. The court then called back Juror B, who denied making any negative comment about the defendant. After questioning the jurors, the court consulted with counsel. The Commonwealth expressed that if the court struck Juror B, it should also strike Juror A, and the defense disagreed as to Juror A. The court ultimately decided to dismiss just Juror B from the jury. On June 25th, 2024, just before closing arguments were scheduled to take place, the court received information from court security about another issue involving Juror A. A member of the Massachusetts State Police had contacted court security and said that he received information that a juror, thought to be Juror A, was at one of the local posts for the American Legion talking about the case and that there may be recordings of her doing so. At roll call for the Canton Police on the morning of June 25th, 2024, a number of officers confirmed that they had heard similar things about the juror. Okay, so this all begs the question, how in the hell does everyone know who Juror A is? And even if somebody said, like, there was a juror somewhere that did something, how in the hell do all the police determine which person that is to identify him or her as Juror A? Or by their name or whatever, provide identifying information about who it is. Is there some sort of explanation for that? Because I don't get it. I don't understand that. How do they know who is being talked about? And why are they all talking about it? What the hell do they know about it? About the jury makeup? Who's who? I don't know. The court called a sidebar to discuss this new information with attorneys. Defense counsel asked the name of the Massachusetts State Police officer who had received the information, and a court officer stated it was Lieutenant Fanning. Fanning is a supervisor in the Norfolk County Detective Unit. During the investigation into O'Keefe's death, he was Proctor's supervisor. He was also one of the recipients of a group text circulated by Proctor that included reference to looking for nudes on the defendant's cell phone, as well as a reference to defense counsel's, quote, retarded client's phone. Defense counsel represents, and for the purposes of this motion, the court accepts that Fanning also interviewed some witnesses in the case. Fanning was not himself a witness at the trial. After explaining the attorneys the situation, the court called Juror A to a sidebar. The following exchange occurred. The court: it's been brought to my attention that you might have been out recently at an American Legion or a Knights of Columbus or someplace like that in Denham, and that someone has reported that you may have been recorded talking about the case. That's the information I received. What can you tell me about that? So I'm going to pause right here, and maybe you guys tell me in the chat, is this the pizza place Albert's recording? Is that who told them about this? Does anyone know? Is that what's going on here? Because I don't understand. How does somebody who's not sitting in the courtroom happen to see a recording and know that the person's a juror? And if they don't know who the person is and they just heard voices on a recording, then how in the hell does anybody identify who the person is? This is what I don't understand. Oh, right. It was a VFW. Sorry. So it wasn't the Alberts recording. So, but who so someone at the American Legion is like watching a video and they hear on this video someone talking about being a juror. Then how do they describe who it is? How does Lieutenant Fanning figure out who it is? And how at roll call are all the police officers talking about which juror it is? Even if they saw the video, at best, you'd think they would have had to go to the judge and said, it's a skinny, short girl with red hair. I don't know. I don't know. Okay, so the court asked that question. The juror responded. So the judge ended with, what can you tell me about any of that? The juror says, I don't know. Have you been at an American Legion hall? The juror, like a month ago. The court, okay. At what time were you all talking about? The juror, not that I remember, no. The court, do you remember if people there mentioned to you anything about this case? The juror, I was drinking, I don't remember. The court, okay. The further information I have is that this morning, several Dedham police officers said that they heard the same thing. Okay, what? Several Dedham police officers said that they heard the same thing. About a random juror? About who? About what? About how? The juror, okay. The court, all right. Could it have happened? The juror, I don't know. The court, okay. The juror, I really don't know. And she cites the trial transcript. The court asked the juror to step aside and then discuss the matter with the attorneys. The Commonwealth expressed concern that the juror had been involved in the previous issue and requested the juror be excused. The defense objected, arguing that the previous incident was unrelated. Focusing on the incident, the court conveyed a concern that the juror did not deny the incident, but instead stated that she had been drinking. The defense responded that the court should consider that no other juror had been affected and that the source of the information was a Massachusetts state police officer. Come on, Judge Cannone. Can you take this into account? Do you realize the issues you're having with the Massachusetts State Police? You're going to take their word at face value? Returning to the body. Thereafter, a discussion about Lieutenant Fanning ensued with defense counsel suggesting that Fanning and the Massachusetts State Police may be, quote, targeting potential jurors for the purpose of trying to get them excluded from the jury. The court allowed defense counsel to make its arguments about why the court should not dismiss the jury. ADA McLaughlin then explained to the court and defense counsel Lieutenant Fanning's role. Lieutenant Fanning is the commander of the extensive security operations that this case has required.
He's an honorable cop. What an honorable guy.
So if ADA McLaughlin says, I'm going to ask the judge again, Your Honor, do you tend, or automatically for that matter, accept anything an ADA says as truthful? Do you tend to believe things an ADA says more than you would an average citizen or a defense attorney for that matter?
I'll allow it.
And for those of you that don't know, that's referring back to the conversation had in court again today about the jury questionnaire, about how important it is to ask the jurors if they tend to believe a police officer more than the average citizen just because they're a police officer. Ugh.
I mean, it's bad enough having to worry about jurors, having to worry about judges too. It's too much. It's too much for one person to handle, really.
All right. So again, ADA McLaughlin's the word from the heavens here. Lieutenant Fanning is the commander of the extensive security operations that this case has required. What occurred is he received the information. He did not investigate. He had no evidence of a crime. If he did investigate or reach out to anyone, that could have been considered an improper influence on a jury. What he did is reported it to the chief of the trial court security to make the trial court aware, as it is simply a trial court issue. The Commonwealth then made its argument regarding why the court should dismiss Juror A. The court then conveyed its decision. I believe there's credible evidence that this juror has had a conversation about this case. She did not deny it. I find that there has been a violation of the court order for failure to report it on a repeated basis. Juror A had no problem reporting the other juror, but then at the time also did not tell us that she spoke to the two other jurors I inquired of. She told us they may have overheard, and then it was, in parentheticals, another juror identified by seat number, who ultimately told us that this juror had reported to her what the other juror had said. Juror A may not remember whether she spoke about this case, but it wouldn't surprise her if she remained as a juror if we did hear from, but I wouldn't be surprised if she remained as a juror if we did hear from someone who was at the VFW that night after all of this. So for all those reasons, I'm going to excuse her from sitting on this jury. Say what?
Just says bullshit.
Wait, what? I wouldn't be surprised if she remained as a juror if we did hear from somebody who was at the VFW that night after all of this. What the hell is she saying?
What do you mean? That's from what? It's from The Wire. She
Judge, not the soundbite.
Oh, sorry. Sorry, babe.
At this point, the sidebar conversation continued about Lieutenant Fanning. The following exchange occurred. ADA McLaughlin. What I said was that Lieutenant Fanning is the unit commander of the security operations, which I know from personal the past 3.5 months. That's his role. Attorney Little. For the jury, the court. Hold on. ADA McLaughlin. Not for the jury, for trial support and security. You're at B.
Defendant's argument: a criminal defendant is entitled to a trial by an impartial jury pursuant to the Sixth Amendment of the United States Constitution and Article 12 of the Massachusetts Declaration of Rights. And they cite Commonwealth v. Williams, 2019. The defendant here argues that her Sixth Amendment right and Article 12 rights have been violated by the court's dismissal of Juror A. According to the defendant, the court's dismissal of this juror was improperly based on the juror's views of the case. Specifically, the defendant contends that Juror A appeared sympathetic to the defense, and therefore the MSP, who have an interest in the defendant being convicted, targeted the juror to get her dismissed before deliberations. Defendant
Wait,
also
I've got a question there, though.
Yeah.
How in the hell would the Massachusetts State Police know if a juror was leaning towards the defense? I kind of don't. I kind of don't
They were
get
saying
that.
because she was wearing a pink shirt at some point. Like, so they took that as, which I don't know if it's true or not. I heard that shit though.
Yeah, but you can't wear pink ever. I mean, what if
No.
somebody happens to wear pink?
No pink for you. No pink for you.
So that's
Not
what
if you're in Dedham.
So
Not if
they
you're in Dedham
decided
courthouse.
somebody told the Massachusetts State Police that the juror didn't he say he never saw the jurors? How does the Massachusetts State Police know she wore pink?
I don't know. They heard about it at the VFW.
Hey, you know what I heard? There's a
juror was
juror
wearing
that's wearing pink. Gotta get her ass off the jury. Do it. Do it.
The defendant also argues the court failed to employ the proper process before dismissing the juror. These arguments have no basis in fact or in law. The defendant's first argument relies on a significant claim to clairvoyance about Juror A's sympathies at the time of the sidebar conference, and it is premised on unsubstantiated claims regarding Fanning's involvement with the jury, despite being specifically informed at sidebar that Fanning was not in charge of the security for the jury, and without providing any evidence that Fanning ever interacted with any member of the jury. Defense counsel repeatedly claims, without any evidentiary support throughout their memorandum in support of the present motion, that Fanning was, quote, commander of jury security or in charge of jury security and had access to and control over the jury at the first trial. In fact,
Wait, footnote.
Footnote 10. I hope it's short. The defendant argued at the hearing on this motion that it is reasonable to assume that Fanning had access to the jury because he apparently knew or became aware that the person involved in the incident at the American Legion Post was a juror in the Reed trial. In fact, this is the very opposite of a reasonable assumption. Is it?
I'm left here wondering. That's what I'm screaming about.
Is it fact finder?
How
She's
did
fact
they?
finding right there? How does she know what's reasonable and what's not reasonable? Unless she's finding facts. Is she finding facts here?
She's finding something.
She's finding something. Just find something. Find some bullshit. Find some bullshit. Were you going to say something, or can I continue?
You can continue. I forget.
Moving on. In fact, as made clear to the defense counsel at sidebar on June 25 of 2024, Fanning was the commander of security operations during the trial and not in charge of the jury. Footnote 11. Defense counsel submitted an incomplete transcript of the June 25, 2024 sidebar discussion, omitting the part where ADA McLaughlin states in no uncertain terms that Lieutenant Fanning was the commander of security operations, not for the jury, but for trial support and security. Same shit. What, are you kidding me? Same shit. He's commanding the people that are watching the jury. He's the boss. He's the boss of all of them. Hey, you tell me. I'm your boss. You tell me what you saw. You tell me what you hear. I'm the boss.
I honestly do think it's fair to assume, like, not for the jury specifically, but for the trial support and security for everything, including the jury, that was a fair assumption by
he's the boss.
But it wasn't good that they left out that following sentence. They should have.
I mean,
always,
you think people, you're not the boss of me. Yeah, I'm the boss of you.
I would have put it in and said, but ADA McLaughlin's characterization is nothing more than her characterization.
She's calling this shit clairvoyance, girl. That's what she,
well, clairvoyant is how the hell they figured out who that juror was in order to convey it. I want to know, Judge Cannone.
I heard it over there by the VFW.
No, but
Yeah,
did
I
they
heard it.
say
I heard things.
it was a short juror, 5'2", thin build, red hair, like, or did they say it was juror so and so?
It was the chick in the pink shirt with the red hair.
All right. Fanning's role at the first trial related to the significant, unusual security concerns caused by large crowds in the immediate area of the courthouse to ensure the defendant's right to a fair trial, an impartial jury free from outside influence. The court instituted a buffer zone around the courthouse during jury selections and throughout the trial. The MSP and local police enforced the buffer zone. Fanning, a supervising officer assigned to the Norfolk District Attorney's Office, was one of the commanding officers outside the courthouse. Emphasis added by Judge Beverly. Trial court is responsible for jurors. Court officers employed by the trial court, and only those officers, are, quote, in charge of the jury. The only, like, she's taking so much, oh, how dare you impugn the integrity of the court, but yeah, go ahead and put shitty Valley, like the Sallyport videos on. I don't care. I don't care. Her feigned.
It is supposed to be true that the only people who have access to the jury are
Yes,
the court officers.
100%. I mean, I was saying that it's always like in our jurisdiction, it's a bailiff. Like the court bailiffs handle all the jury shit, period. And they're not cops. They're all old retired guys. The only people with access to the jury at the courthouse are the court officers of the trial court. Court officers have sworn duty to watch over the jury. That responsibility was not and cannot be transferred to the MSP. Thus, counsel's claim that Fanning was in charge of the jury and was directly involved in the efforts to have one of the jurors dismissed. See, id is simply false.
But he was directly involved in the efforts to have one of the jurors. I mean, he reported the juror, and my only question really is, I mean, there's not an issue with that, right? If someone's like reports to the Massachusetts State Police, hey, I overheard a juror talking, and then the Massachusetts State Police conveys that to the, but why didn't they get the recording? Why didn't someone say, I need to see this recording? There's an allegation that this is made up. And if there is some, does anyone in the chat know, was there some sort of issue with this juror wearing a pink shirt, or what is the basis for the defense to say that this was an attempt to get off a defense leading juror when in theory, no one, not even the court officer, should know which way a juror leans? So was there anything about a shirt, or was there something that about this juror beforehand that, you know, what it also could be is that juror reported juror B for talking smack about Karen. You know what I mean? So that in and of itself kind of makes her maybe seen as defense oriented. If she's saying, oh, I don't think it's right that this juror was complaining about the facial expressions the defendant makes. That does imply that she's taking sort of offense to juror B's characterization of the defendant and didn't think that was fair to the defendant that she's telling other jurors that. So if someone knows which juror did that, then I guess that puts a target on juror A's back. So that to me is what I see as a way that people who were aware of how juror B came to be dismissed would know that juror A might lean towards the defense.
So it is, of course, required that lawyers present only good faith arguments to the court under all circumstances. What is she now going to flamethrower the defense now? Oh, God. It is, of course, required that lawyers present only good faith arguments to the court under all circumstances. But
I can't take it.
Yeah,
I cannot take it. Are you fucking kidding me right now? She's taking the opportunity in the motion to dismiss, where she did not say anything negative about what the prosecution did, to complain about the defense's candor to the court.
Seems
Are
like
you fucking kidding me?
Sounds like it. Sounds like it.
And I don't have an issue with her pointing out if the defense is lacking in candor in their arguments, but what about the freaking misconduct, the prosecutorial misconduct, the police misconduct, the blaring misconduct that you're not even pointing out, that you take no issue with? Inverted schmurted.
Just a little pat on the butt. It's
Inverted
okay,
schmurted.
Hanky. I got you, big guy. I got you. I'll allow it. But the failure of counsel to take care with the truth of their assertions in this regard has particularly damaging consequences. Wow. This case has generated substantial public interest locally and nationally to suggest without factual support that an MSP officer had influence over the court and the jury in the first trial.
Who gives a shit that they misinterpreted that this guy was, overseeing the court? What about lying to the jury, Judge Cannone? What about, you can point out both wrongs? You can point out both wrongs, but apparently you can't. So, I mean, you could have, but you didn't.
Moving on. That's such a great phrase that I've adopted from you. To suggest without factual support that an MSP officer had influence over the court and the jury in the first trial is to invite unwarranted public speculation and distrust about the integrity of the Massachusetts judicial system. No shit, Pav. No shit. You did that. You do it. You completely do it all the time. All these things that you write up, this shit that you do in court, the things that you put paper to pen or paper to pen or pen to paper, whatever the case, it's like she's created the situation.
How dare her?
It's ridiculous.
How dare her? They're not even your elected officials. They're not the representative of the entire county for truth and fairness. What the fuck is going on here? How dare her?
It can also be seen as an improper attempt to influence potential jurors in advance of the retrial. Thus, the court takes this opportunity to make clear that neither Fanning nor anyone else from the MSP interacted with members of the jury or influenced the court's decision to dismiss Juror A in any way. When Fanning became
Unless
aware,
there's not a recording on a VFW somewhere of this woman saying anything to anybody.
Yeah.
I mean, she did kind of say, not that I remember, I don't know. Maybe it did happen, but.
When Fanning became aware of the information regarding Juror A, he turned it over to the court officer assigned to the case because it was a matter to be dealt with solely by the trial court. The defendant also argues that the court failed to employ the proper process before dismissing the juror. This argument is based on an incorrect understanding of the law with respect to the process the court must undertake when presented with an issue as to a sitting juror. A judge has discretionary authority to dismiss a juror at any time in the best interest of justice when there is an indication that a juror is unable to perform his or her duties. Wow. His or her duties. A judge may properly discharge that juror. And that's Commonwealth v. Campbell. Where a judge has reasonable concern that a sitting juror cannot comply with the court order to not discuss the case, the judge, after individual voir dire, may dismiss the juror. Commonwealth v. Hampton again. Judge's decision to remove juror after jury had been sworn was not an abuse of discretion, where trial judge found that the juror had violated court order. The jurors were not to discuss the case with other jurors. When alerted that Juror A might have been talking about the case at a local American Legion post, the court explained the situation to the attorneys and then called the juror in for questioning. Juror A did not deny that this occurred, but rather stated that she did not remember and that she was drinking. The court then heard argument from counsel about what action should be taken. In deciding to dismiss the juror, the court considered Juror A's equivocal answers to questions about the incident, as well as the fact that there was a previous incident involving Juror A, which she was not entirely forthcoming about her communication with other jurors about Juror B. Thus, the court considered the American Legion post incident to be a second failure by Juror A to comply with the court's order not to talk about the case.
Why didn't she ask to see the video? Why didn't she say, I want someone to get this video, email the video to me. Email the video to me. I want to know what was said.
Proofs. We want proofs.
I mean, there is an allegation here that they are, that there's a reason not to trust everything the police say to you. So somebody called somebody and said somebody watched a video or heard a video.
Hey, I heard it down at the Legion. That's all you need to know. What happens at the Legion does not stay at the Legion. It makes its way to me, Fanning.
Moving on. Based on the totality of the circumstances, the court decided in its discretion to dismiss the juror. The defendant cites several cases in support of her argument that, quote, post-impanelment but pre-deliberation, if a judge is alerted to potential misconduct or affecting jurors, the judge first determines whether material raises a serious question of possible prejudice.
Wait a minute. The material. The material. Did you look at the video or listen to a recording? Did anybody review the material? What the hell was said? If it's on recording, what was said?
Where's the proofs?
If she so determines, she must, emphasis added, then hold a hearing to inquire further into the alleged misconduct. Emphasis in the original. See defendant's memorandum at 33. Based on the cited cases, the defendant argues the court's questioning of juror A was insufficient. The defendant, however, misunderstands the law. First, the cases cited are inopposite. The primary case relied upon, Commonwealth v. Tennyson, concerns information the judge received about a claim of extraneous influence on the jury, which the co-defendant counsel raised after the jury deliberations had begun.
Okay.
The other cases cited by the defendant also concerned the potential discharge of a deliberating juror.
Okay.
And that's C. Commonwealth v. Tosconi. Finding judge improperly dismissed a deliberating juror for personal reasons. I think your breath smells. You're out. Judge, who found a juror repeatedly disregarded orders not to communicate about the case, acted within his discretion in concluding that there was compelling reason to discharge the deliberating juror, Commonwealth v. Haywood.
So did McCowan, that the one you just read, I don't know, did that require a hearing or didn't require a hearing? Why isn't she saying?
I don't know.
Other cases also involve discharge of a deliberating juror. The rest say, the first one you read, Tosconi, says no. Well, the first one was Tennyson, specifically in the quotes, deliberating juror. Tosconi, deliberating juror. McCowan. Oh, it does say deliberating juror. Okay.
Proofs. We want proofs.
I mean, there is a difference between a deliberating juror and a non-deliberating juror. I haven't done the research to determine it independently, but it makes sense to me why, if they're in deliberations, it would require a full hearing before a judge could use their discretion to dismiss the juror. So go on to Haywood. Sorry, that 1979 case.
Moving on. Before a juror is excused from deliberations and replaced by an alternate juror, the judge should hold a hearing and be fully satisfied that there is a meritorious reason why a particular juror should not continue to serve. And then we've got Garcia, finding judge improperly dismissed a deliberating juror for personal reasons without the appropriate procedures. Indeed, GLC 234A, Section 39, which governs the dismissal or discharge of a juror, draws a distinction in the process required for deliberating jurors and non-deliberating jurors. The court shall have authority to excuse and discharge a juror participating in jury deliberations only after a hearing, upon a finding of an emergency or other compelling reason. While the defendant appears to recognize there is a difference between a juror who has been sworn in but is not yet deliberating and a deliberating juror, she confuses the distinction in her discussion of the law. The defendant also fails to cite any authority suggesting, as she contends, that the court was required to engage in an evidentiary hearing with Lieutenant Fanning before deciding whether to dismiss the juror. The court here called juror A to sidebar to conduct an individual voir dire, heard argument from both defense counsel and the prosecution, and explained to counsel that the juror would be dismissed based on credible evidence that the juror had conversations about this case.
I credible evidence.
You want proofs? The defendant was afforded all of the procedural protections that she was entitled to before the court made its discretionary decision. See Hampton. Judge inquired of an individual juror and solicited input from counsel before properly dismissing sitting juror pre-deliberation. Order! For the foregoing reasons, the defendant's motion to dismiss for extraordinary governmental misconduct is denied. The defendant's alternative request for an evidentiary hearing on the matter is also denied. There it is. Be outraged. Be outraged. There's
and look, I have to tell you, in
we're not doing Easter tonight. Not doing it. I can only handle so much of her shit in one night.
I have to tell you that I did not. I know that you were really hoping that maybe she might actually dismiss it. I'm sure that
That's a dream, Annie.
Right, changed as like time went by. But I'm more outraged at her, like, just lack of admonishing them in any way, shape, or form.
Nothing.
And that she had the audacity to take the time to bitch slap the defense again, and just has no qualms about them lying to the jury, intentionally misleading the jury. She doesn't even clearly set out that the witness testified and was asked if it was a fair and accurate representation of the room. He was specifically asked, you don't see anyone near that right tail light. No one's by the passenger side tail light. He asked those questions. He explicitly asked those questions. Let's even assume that Lolly's a complete moron and he never looked at the damn video. I'll tell you who did know it was inverted. Was that Higgins that was testifying?
The copper. Bukkake. Buchanan, I mean.
Buchanan. He knew.
Buchanan.
Whatever his name is.
Buchanan.
He knew.
To you, ma'am, it's Bukkake. All right. So, look, we've had our rants. None of us feel any better. It's grossly disappointing. It's not surprising at all. And, trial starts next week.
All right, we already thanked Grin for me for her generosity. Military Mama, thanks for your generosity. Love your content. So happy to finally see you live. Have you all been able to convince Jay to join you for this next trial?
You got a job. You got a job, Military Mama.
Fun combo. Jay can join us anytime he gets off, anytime he wants to.
He knows that.
He loves to have him. He knows it. We'll make sure he knows it again. And Grin for me again. Thank you. If Jay's face isn't on Defense Diary screen during the new Reed trial, you should blacklist yourselves. We could put a picture up if he can't come.
We have a picture right there at the bottom. That's Jay and I as stepbrothers right there. Jay is Will Ferrell, and I'm what's his face? The other guy who I love. I just can never remember his name, but I love him. I'm sure the chat will let me know. Okay, so
that is Jay.
It is Jay. Well, Jay is Will Ferrell's role.
Right. And bear in mind, Bob would love to have Jay because hi, Scout, because at some point I'm going to be covering the Lori Vallow trial while Bob's covering this. So,
Whoa, dude, I'm on a ball.
Billy Juno, thanks for your generosity. And then Billy was right. He said, or he or she said, I cannot wait for Bob and Allie to rant because it gets so much worse. And that was an early comment.
Thanks, Billy Juno.
She's like Texas. Thanks for your generosity. You know the rulings are bad when Melanie drops F-bombs during her live. Was that happening? Wow. No ducks, just fucks?
No, that's right.
All
You
right.
should get that t-shirt made for her, by the way. Julio. All right, I'll take care of him from here, babe. We're going too slow. Julio, $4.99. Thank you a million times over. Is that Awkward Family Photos website? No, that miracle was made by Mandy. Thank you so much, Julio. Ryan S. Free Karen Reed gifted 1 DD podcast membership. Thank you so much, Ryan S. We appreciate that. And I'm sure the beneficiary of that appreciate it as well. Sandy B. $5 holla. It's okay because everything that was turned over caused no harm because guess what? She gets a new trial. It's all good. XOXO. She is so corrupt. Thank you. Thank you for that. Julio came back with another $5 holla. What is CPD looking at video when we were supposed to be excluded from the case? It's a good question. $1 million question.
Yeah.
Here's Michelle, $10 holla. She blew my mind by letting me know that Massachusetts appoints all their judges and they're not elected. Shocking.
Thanks for your
Shocking.
generosity.
Thank you, Michelle. Steve Trammell, $5 holla. Judge Bev is a former PD. God help her former clients. Hear, hear.
Thanks for your
Probably right.
generosity, Steve.
Thank you so much. Julio came back. She cites a 2025 case for what happened in 2022. Really?
Well, I mean, she was citing it for the because I saw that as well, and I almost thought the same thing. But she was citing it for the proposition that the law in general seems to distinguish physical evidence from video evidence. I don't know that was. I just don't think that that's what this should even rest on. I mean,
Either.
you've got to default on the side of preserving, and it's technically physical evidence. It's physical evidence. So, but
our very own Lisa Shelton blasted in with 10 DD podcast memberships. Thank you, Lisa. We appreciate you so much. Lisa came back with another $5 holla. This is just weird to me. Do you think Bev just had already made up her mind in round one and that she was guilty in some form? Sure acts like it, doesn't she? Thanks, Lisa. No more pandas, $5 holla. I wonder if the Baldwin judge spends her evenings throwing shoes at her TV when she sees this nonsense. I would imagine so.
I mean, she took it seriously.
She did. She bombed that case right out of that courtroom mid-trial, no less. Thank you so much for your generosity. Jurisprudential maladies. Good one. Member for 9 months. Aw, family hug. 9 months of Bev's BS, and all I get is this lousy sticker. You're here.
Thanks for your
Thank you
generosity.
for being, thanks for being a family member. We appreciate you. Julio, why is retrial acceptable law? I don't think it is. So they can bankrupt you more than they already have. As Allie says, it's absurd.
It is. And thanks for your generosity with all these super stickers.
Big time. We really appreciate it. Caroline Peltier. $5 holla. How long until we get the metadata?
How long till we get the metadata? Thanks for your
Never
generosity.
30.
Caroline.
Never 30. That's when that's coming in. Thank you, Caroline. Julio, final super. Silver lining. This is now Bev's legacy as a judge for the rest of time. True that. Can't think of a better way to end this. All right, you guys. We love you. We thank you. Make sure that you give us a like on the way out. Make sure that you sub. We're growing. We're so close to 40,000. It would be amazing to hit that this week. We're really, really close. So we thank all of you guys. Subs, you're amazing. Thank you a million times over.
Tell your friends to subscribe so we can hit that 40 mark.
Yeah,
Alex
wants to skip right to 100.
Right,
right to 100. She wants to skip like everything 40 directly to 100.
Right.
So we got to do the work, babe. We got to do the work. Mods, thank you so much for your hard work all day.
All day.
Mandy and Tracy, thank you guys so
Can't do it
much for
without
everything you do. Can't do it without you guys at all. And I know I saw somebody's like, I've never seen a channel with this many mods. We got to keep it tight in here, man. We get when you rant and rave as a defense attorney, you'll get some trolls, so we got to keep it tight. So thank you, mods. You're amazing. Just remember, you guys, without you guys, I am just an old man talking about
a shit ton of cases.